I want to start by going through a basic timeline on the history of the juvenile justice system, and then I want to give you all some background, a little more background context afterwards. As early as the 1800s, children as young as 7 could be tried and sentenced to death. During the late 1800s, a push for reform began. So during the progressive era, it was a period of widespread social activism and political reform across the United States. And this led to the establishment of the first juvenile court in 1899 in Chicago. And this court was the Cook County Juvenile Court, which is pictured on this slide, actually. This started the juvenile justice system. The juvenile justice system was originally founded on the idea that rehabilitation was of utmost importance. And so there was a need for special courts and facilities for juveniles. It was founded on the idea that the court was actually responsible for the care and protection of our youth, or parens patriae. From 1900s to the 1960s, many states began to develop their own juvenile courts. At this time, probation officers became responsible for most juvenile justice activities. However, there became so many cases that it was hard to give effective individualized services. And so this led to increasing criticism of the system, which further led to misuse because there was increasing sentiments that the juvenile justice system needed to implement harsher punishments. In 1974, because of all of the criticisms that were arising, Congress passed the Juvenile Justice and Delinquency Prevention Act, or the JJDPA, and this provided federal protections to juveniles. However, despite the passing of this federal legislation, there still remained an increase in tougher state legislation and an increase in detention rates. During the 2000s, there has been a hope for reform after an unprecedented increase in juvenile arrests and detention in the U.S. So I mentioned this a little earlier, but the juvenile justice system was founded on the concept of parens patriae, which authorizes the state to legislate for the protection, care, custody, and maintenance of children within its jurisdiction. Most juvenile courts have jurisdiction not only over criminal delinquency, but also abuse and neglect, status offense delinquency cases, and dependency cases. So basically cases involving child welfare services. The concept of parens patriae is that the juvenile court provides less due process, so less formal processing and protection, because the court was supposed to be in the best interest of the child. In fact, this doctrine literally translated in Latin, in English from Latin, means father of the country. And it gives the state an inherent power to act like a parent and sue on behalf of its citizens to protect them from harm. In this case, the citizens are kids. However, Kent versus United States in 1966, Henry Galt in 1967, Henry Winship in 1970, McIver versus Pennsylvania in 1971, and Breed versus Jones in 1975 were all Supreme Court cases that actually resulted in advancements in procedural due process rights for juveniles and a decrease in parens patriae. I want to explain a little bit about what procedural due process is. It's a legal doctrine in the United States that requires government officials to follow fair procedures before depriving a person of life, liberty, or property. So essentially, they realized that granting juvenile courts parens patriae did not actually adequately protect juveniles. And so juveniles needed federal procedural due process protections and rights. And by the end of the 1970s, juveniles had almost all the same procedural due process rights as adults, except for the right to juries. And they still don't have that right. The Supreme Court found that juvenile justice is not an inherently adversarial process, and thus juveniles are not entitled to a trial by jury. So in regards to juvenile justice, it's important to note the differences in federal and state law. Federal standards include case law, so like the Supreme Court rulings we just discussed. Those cases resulted in laws that are a matter of constitutional rights, not necessarily juvenile justice processes. And the other primary federal standard is the Juvenile Justice and Delinquency Prevention Act, which, again, is the main federal statute relating to juvenile justice. It provides basic core protections, kind of similar to the constitutional rights in the Supreme Court cases. And it also assists states in providing community-based services for them. State laws are what most affect juveniles. The 10th Amendment to the Constitution gives states the rights and powers not delegated to the United States federal government. And juvenile justice processes and practices are not specifically delegated to the federal government, so the state controls them. States generally have jurisdiction over creating juvenile courts and establishing juvenile delinquency processes for youth under the age of 18. And this, again, is pursuant to their state police powers that they're granted in the 10th Amendment. From the establishment of the juvenile justice system to now, there has been a huge shift in attitudes towards it. In the beginning, during the late 1800s and early 1900s, the establishment of the juvenile courts was for rehabilitation as opposed to punishment. The belief was that children should not be treated as criminals. They're kids. So there was a focus on the offenders and not the offenses. However, during the 1950s and 1960s, public confidence in the treatment waned, again, because there were just so many cases that it was hard to give really effective services. And so due process protections were introduced, and instead of empathy, trust, and a spirit of rapprochement, there became increasing sentiments of fear, threats, and short-term detention. During the 1970s, social issues, public fear, and political rhetoric that arose during the Jim Crow civil rights era lingered and contributed to tougher legislation and increased detention rates of juveniles. Minority juveniles were incarcerated at an alarming rate as they were seen as violent and a threat. Since 1960, arrests of juveniles for violent crimes in America have increased by about 250%, more than double the comparable figure for adults. In the 1980s, the pendulum began to swing towards law and order. The 1990s have been a time of unprecedented changes as state legislators implemented tougher legislation on juvenile crime through the ideals of law and order. Over 1 million youth are arrested in the U.S. each year. This is what 1 million looks like. So 1 million kids deal with law enforcement or have some sort of interaction or engagement with law enforcement each year. And only 2/3 of juvenile offenders that are held for nonviolent charges or status offenses, some of which would not even be illegal if they were not minors. So we see that 36% of the status offenses that draw kids into the system are because of truancy, 22% because of liquor law violations, 12% because of being ungovernable, 11% because of running away, 10% because of curfew violations, and 9% because of other reasons. These are the main reasons kids are being drawn into the legal system. For federal crimes, the minimum age of criminal responsibility is 11. But at the state level, 33 states have set no minimum age of criminal responsibility, meaning juveniles can be charged at any age. In fact, in 23 states, children as young as 7 years old can be prosecuted and tried in adult court. Each year in the U.S., an estimated 250,000 youth are tried, sentenced, or incarcerated as adults. And this is what 250,000 people looks like. And this is about how many kids are tried, sentenced, or incarcerated as adults. This is often because of a lack of state law protections and people voting yes on harmful propositions. Every year, 100,000 children are held in adult jails and prisons, with more than 3 out of 4 awaiting trial. And this is what 100,000 people looks like. So this is how many kids are in adult jails, often just simply awaiting trial. This is unacceptable. In fact, the federal law requires that children be protected while in custody. So, this is just a really horrible problem. Juveniles experience sexual assault in adult prisons. In fact, many have fought to pass the Prison Rape Elimination Act in different states, but it doesn't exist in all states. Regardless, again, juveniles in adult prisons is horrible. Juveniles also experience a higher likelihood of suicide. In fact, juveniles are 36 times more likely to commit suicide if placed in an adult prison. And about 80% of youth convicted in adult criminal court will reoffend later in life. And the fact of the matter is that the system disproportionately affects Black kids. Black children are 5 times more likely than white youth to be incarcerated. And although Black kids represent less than 14% of all American youth under the age of 18, Black boys make up 43% of the male population in juvenile facilities, while Black girls make up 34% of incarcerated girls. We need to stop implementing harsher penalties, as they are also often targeted towards minority youth. Youth are accountable, but in a constitutional sense, they're different from adults. And just in real life, they're different than adults. They should not be receiving the harshest of punishments, yet in many states they do. In fact, 29 states still allow life without the chance of parole as a sentencing option for juveniles. Miller versus Alabama and Jackson versus Hobbs are 2 Supreme Court cases that jointly held that for juveniles, mandatory life without parole sentences violate the 8th Amendment. Some states have applied these rulings retroactively and others did not. Some states still allow these kinds of sentences, and some have made modifications, but they provide mandatory minimums ranging from a chance of parole after 15 years up to 40 years. Life experiences of juveniles serving life sentences are often marked by difficult upbringings with frequent exposure to violence, and oftentimes they're victims of abuse. 2012 Sentencing Project found that in regards to defendants that are given these kinds of sentences, 79% of them witnessed violence in their homes regularly. 32% grew up in public housing. 40% had been enrolled in special education classes. Fewer than half were attending school at the time of their offense. 47% were physically abused. 80% of girls reported history of physical abuse, and 77% of girls reported histories of sexual violence. Furthermore, adolescence is marked by rashness, inclination for risk, and inability to assess consequences. Youth should not suffer lifelong consequences for decisions made while kids. We need to stop preying on our youth. Beginning in the wake of the shootings at Columbine, the high school shooting, a small town in Pennsylvania elected a charismatic judge who was hell-bent on keeping kids in line. Under his reign, over 3,000 children were ripped from their families and imprisoned for years for crimes as petty as creating a fake MySpace page. When one parent began to investigate and question this harsh brand of justice, it was revealed that the judge had received millions of dollars in payments from the privately owned juvenile detention centers where the kids, most of them in their early teens, were incarcerated. A couple of parents were actually convinced to allow their kids to be arrested, thinking it would be like a scared straight experience. So the parents cooperated with law enforcement, some of them, not all of them. Little did they know their kids would end up on drugs, go on to engage in more criminal behavior, develop mental health disorders such as PTSD, anxiety, and depression, and be consumed by rage and despair because their opportunities for college and ultimately in their lives were affected. So how can we make a change? First, we have to look at the structure of the current juvenile justice system. This is what the standard juvenile justice system looks like or consists of. And although there are differences among juvenile courts and case processing, there are stages that they all must go through. So first, before any court processes come into play, a juvenile must be referred to the court. Referrals may be made by police, parents, schools, social service agencies, probation officers, and victims. Cases that are referred to the court are screened through an intake process in which charges are set forth. The intake screening determines whether a case should be filed filed or not because of insufficient evidence, or if it should be resolved by a diversion program, or requiring them to do a specific set of conditions, or if they should proceed to formal processing in the juvenile court. Petitioning is the formal processing in the juvenile court. It's similar to indictment in adult criminal court. Juvenile courts may vary by the extent of services for which they are responsible. So some courts oversee only the adjudication process, while others provide an array of services pre-adjudication and post-disposition. Over half of the states have a system where juvenile courts administer their own probation services, and many are responsible for detention and intake. If a case proceeds to formal handling, so court and trial, a petition is filed and the case is scheduled for an adjudicatory hearing in the juvenile court, or the case may be waived to adult criminal court. But in juvenile court, three things may happen. The juvenile may be judged to be delinquent, so similar to being found guilty in criminal court, and scheduled for a disposition hearing, similar to a sentencing hearing. Or the juvenile may be found not guilty and the case may be dismissed, or somewhere in between, the case may be continued to contemplation of dismissal. In this case, in the meantime, the juvenile may be asked to take some action prior to the final decision being made, such as paying restitution or receiving treatment. At any point during the process, some juveniles may be held in a secure detention center. So probation is pretty big in the juvenile justice system. Most juveniles who are adjudicated delinquent or found guilty are put on probation. Juvenile probation departments have three basic functions: intake, screening of cases, pre-sentence investigations, and court-ordered supervision. Over one half of juveniles adjudicated delinquent in juvenile court are put on probation, and 1/3 of the cases that don't even make it that far, so don't even receive formal processing, are placed on probation at intake. The current juvenile justice system has proven to be ineffective. It fails to take into account the specific needs of juveniles and their social backgrounds. In order to create a more effective juvenile justice system, we have to consider many different things, including risk assessment. This diagram is just one representation of a system that takes into account the many considerations necessary for an effective juvenile justice system. And the following are the most effective reformations and best practices for juvenile justice. First, to create meaningful change, we just need system reform. System change is the intentional process designed to alter the status quo by shifting and realigning the form and function of a targeted system. Formal justice system involvement is associated with poor social, economic, and health consequences for youth, including increased school dropout, unemployment, substance abuse, and worse mental health outcomes. There is a need to develop juvenile diversion programs that allow for early intervention but prevent formal system involvement by handling cases through alternative mechanisms, not the formal system that exists. Again, diversion programs that bring first-time or low-level offenders into the formal justice system may have a stigmatizing and ultimately harmful effect on juveniles. Systems must engage in quality, meaningful collaboration so that we can restore youth's faith in societal institutions as sources of protection and support. Research increasingly points to the importance of designing comprehensive, integrated approaches for improving the outcomes of youth who are part of multiple systems. So, for example, youth who are in the child welfare system and the juvenile justice system. Such approaches should involve multi-system and interagency collaborations between child welfare services, juvenile justice professionals, law enforcement, education, and behavioral health personnel. This might sound basic, but there's not functional cooperation between these systems at the moment. But it's necessary so that the needs of juveniles are really assessed and the needs are addressed through coordinated case planning, intervention, and supervision. In addition to comprehensive integrative approaches and interagency collaboration, some alternatives to formal system involvement include restorative justice, teen court, and juvenile drug court. Restorative justice is a system of justice. It focuses on the rehabilitation of offenders through interaction and reconciliation with victims and the community at large. This can be through mediation and other forms of dispute resolution. Restorative justice has proven to result in statistically significant reductions in recidivism. Teen court involves core elements that include the involvement of volunteer youth, sometimes peers, in court proceedings, decision-making, the use of sanctions intended to support positive development, and it gives youth the opportunity to avoid a criminal record through successful program completion. Teen court, though a prevalent model across the United States, does need some improvement and further development, but it can be a great alternative to formal justice system involvement. And finally, juvenile drug court, specifically as a part of the Reclaiming Future programs, has also shown very promising strategies for improving system integration. In addition to system reform, we need to implement the best practices, which are typically community-based solutions. The school to prison pipeline has moved scores of young people from classrooms to courtrooms. So a lot of the times it starts with education or lack thereof. Increasing concerns about school violence and a growing awareness of bullying led many schools to hire police and to institute zero tolerance policies. This might not be common in every community, but it is especially prevalent in urban communities. This resulted in a dramatic increase in suspensions, expulsions, and even in-school arrests for misbehavior that up to that point had just been normal for school children. Taking kids out of school disrupts their education and often escalates poor behavior because you're moving the kid from a structured environment and giving them increased opportunity to get in trouble. Also, when youth are pushed out of the school system as a result of a failure to appropriately help them with their mental health and education services, they're likely to be pushed into the juvenile system through arrest as a result of behaviors consistent with their disabilities that were never appropriately addressed. Cognitive behavioral therapy interventions and family-focused interventions based on an ecological framework have been fully established as key ingredients for successful interventions with delinquent youths. Many of the model programs that target young people who are at risk for delinquency often involve the family in applying strategies of CBT. Cognitive behavioral treatments for juvenile offenders are designed to correct dysfunctional thinking and behaviors that are associated with delinquency, crime, and violence. And family-focused interventions correct relationships and trauma of maltreated youth and those with traumatic family histories of criminal activity, substance abuse, mental health issues, and domestic violence. So creating a trauma-informed juvenile justice system is not some rapid transformation, and it often requires a paradigm shift in how we view this problem and how to approach it at multiple levels, including changes at the law enforcement level, courts, probation, diversion programs, detention, and mental health services. Reform requires recreating the framework of abnormality and criminality. This includes redefining juvenile delinquency. The success of a community depends on its ability to address specific social issues and to evolve accordingly. Ultimately, transformative communities allow for changes in social, cultural, and political processes within the community. Transformation within communities means developing an encompassing framework and redefining how those within the community interact and relate with each other. This is a key to reducing crime rates, recidivism, and mass incarceration of marginalized groups of people. Transforming communities can play a part in humanizing social justice issues. Juvenile justice reform is transformative reform. The Juvenile Justice and Delinquency Prevention Act sets core safety standards for juvenile offenders, as we talked earlier about. They give core protections, and it aims to prevent delinquency and curb racial and ethnic disparities in juvenile justice system. It also assists state and local communities in helping youth who are at risk. The problem is that funds are not always allocated appropriately. Jurisdictions are not uniform in their approaches and even attitudes toward juvenile justice, and the funds are arguably not being used efficiently to achieve sustained change. I know that in LA, actually, like a couple of the years in which they've received funding, they didn't even use all of the money that they were given. In December 2018, after 16 years of inactivity, Congress approved a 5-year reauthorization of the JJDPA. That's the most recent update on this legislation. Because the states are given police powers and control over juvenile justice processes, it's important that we get involved through informed voting on juvenile justice policies that are on our ballots. We have to look for propositions on our ballots because many of them are actually harmful. For example, in California, within the past 15 years, there's been 2 propositions, Proposition 21 and 57, which both involve sentencing juveniles as adults. Informed voting on propositions are one way we can get involved in juvenile justice and within our communities. As a nation, putting our children behind bars has drastic negative implications. Kids are not able to fully develop, and then they're not given the opportunity to correct their traumas or misbehaviors appropriately. The youth is our future, and it's critical that our juvenile justice system is effective and allows for youth to grow and transform as young members of society, as opposed to leading our youth to more crime all the way into the adult criminal system. We have to fight to keep our kids out of jail, attend local community forums, and get out and vote. Investing in our youth is an investment in our future.